What is a workers' compensation hearing? When in your case do you typically have to attend one? The workers' compensation hearing is a formal meeting where the parties get together and the workers' compensation board, through its administrative law judges, decide if a worker should get benefits that they're applying for, whether it's monetary benefits, medical benefits, or both. That's usually done at a hearing. Hearings are held when there are issues in a case where the parties can't reach a resolution. So if we're saying that our client is entitled to money and the insurance company is saying that they're not, we'll say that the issue is joined and we'll ask for a hearing, and that's how we usually get a hearing. A hearing is typically to sort out any type of disputes related to the workers' compensation claims, such as how disabled the worker is and what the corresponding awards of compensation should be, whether their lost time is related, whether their lost time is compensable, treatment requests which were denied, temporary or permanent disability could be the subject of a hearing. It could be a combination of issues, average weekly wage and the awards that come from determination of the average weekly wage. Most of the time, it's the injured worker versus the insurance company, and the judge is there to hear the facts and make a decision. How does a workers' compensation hearing typically proceed, and what can injured workers expect during their hearings? So right now, the board does want you to appear virtually. They want you to log in. On your hearing notices, a QR code and instructions on the board's website on how to appear virtually. We're in a day and age where everyone has computing access of some kind, whether it's as basic as a phone with a camera. You can appear virtually on your phone. There's an app that you download. The board has very clear instructions on how to download the app and how to participate in your hearing virtually. It's not very difficult. It's pretty straightforward, and you can appear virtually where you will see and you will be seen. You'll see all the parties that are present in your hearing, and they will see you. And that's the preferred method. If you have an attorney, I tell my clients, if you want to appear virtually, feel free to come into the office and we'll sit down together. I'll pull up a chair right here next to me and we could do your hearing side by side, much like we're in court together. And it certainly makes things easier and a little more comfortable for the client knowing that they're right here with me. But what seems to be the most common, and unfortunately because I think it takes away from the hearing process and certain judges have an issue with it, is when you appear telephonically. Most of the time, we log you in, we put your telephone number in, and when it's time for your hearing, the judge will call you on the phone and you pick up the phone and you're there, but you're just there in voice only. Please keep in mind, sometimes it's going to come up as a strange number, and I, like many other people, sometimes when a number pops up that you don't recognize, you don't pick it up. And even more so, we've had numerous clients say, I was so nervous waiting for the phone call that I saw this crazy phone number popped up and I hit decline and I didn't pick it up because I was waiting for the call. Well, that was the call. You missed it. So it's very important that you kind of be on the point here because that's your call. But like I said before, logging in virtually, appearing virtually so you are on video is the recommended way of doing this. It lets the judge see you, lets the insurance company see you. It gives them a better understanding of who they're dealing with. We had a recent case where the client's visible injuries during a virtual hearing played a major influence on the judge's decision against reducing the benefits like the insurance company wanted. So that virtual appearance helped. I think it's helpful if you have a controverted case. If the insurance company's fighting your case, I think your presence, your visual presence virtually helps your cause. It shows the judge that you're a real person and that you have real emotions and that this is a real thing. Personally, I think a lot is lost when it's just over the phone. So my first tip of the day, try to appear virtually if you can. It's not that hard. Generally speaking, one of the big questions I always get asked is, how long is my hearing going to take? Most hearing notices have a time allowance. So it'll say you have a hearing on this date in this part at this time, and next to it or below it, there'll be a little time allowance, 12 minutes, 15 minutes, 20 minutes, 30 minutes. And that's a general guideline of how long your hearing could take. Some hearings run long, some hearings happen very quickly. It really depends on the particular facts. If there's no time allowance, that means there's no time allowed for that. And it should be less than 5 minutes. It should be a pretty quick hearing. Generally speaking, when you do attend a hearing, the people that are there in the virtual room, you're going to have a judge present. You're going to have yourself, the injured worker will be there. Your lawyer will be there. The insurance company's attorney, depending if there's an issue of coverage. I mean, there are cases sometimes, especially uninsured cases, where there might be 4 or 5 or 6 different insurance companies that could potentially be responsible in a case. You could have 6 insurance companies, witnesses with 6 attorneys, and your virtual hearing screen can look like a checkerboard with all the different boxes of people in the room. Don't let it stress you out. Don't get worried about it. Your lawyer will know who each party is and what they're there for and what their role is. Don't let it make you nervous. There might also be witnesses if it's a trial. Employer witnesses might testify. If you have witnesses, they might be present. Various representatives of the employer. Sometimes it could be if there's lawyers in training, if an insurance company has a new lawyer, if we have a new lawyer observing and they're on camera as well. There could be be more than 10 people in a room sometimes in a virtual room. At the start of the hearing, generally speaking, the judge is going to ask whoever requested the hearing to make their case. What is it that we're here for? And at that point in time, if we request a hearing, we might present documents to the judge to review or present them to the insurance company as well. All the documents are uploaded ahead of time. They're present in the electronic case file so everyone can see them. Medical records, unpaid bills, evidence of your lost wages, evidence of your salary, employment records, witness depositions if it comes down to that, witness statements, job search documentation. It really depends on what the specific nature and the purpose of that particular hearing is. Oftentimes, you might be asked to testify. If you're having a trial where you're trying to prove your case and prove that you're entitled to benefits, you will be required to testify most likely. If it's a hearing about permanent disability, there's a very strong chance you'll be required to testify. Testimony before a workers' compensation law judge is much like any court. It's under oath. It's sworn testimony. It's subject to the penalties of perjury. If you are going to anticipate that you might have to testify, talk to your lawyer ahead of time. Make sure that you're prepared. Make sure you're clear as to what you are testifying about. If you're asked a question and you have to testify about a particular topic, you want to limit your testimony to that topic. You don't want to ramble and talk about everything under the sun because it's only going to make things more difficult. You could be asked questions by your lawyer who's representing you to get your story out. You could be cross-examined by the insurance company's attorney and possibly the judge. Maybe the insurance company's trying to show that things are different from what you're attesting and what you're claiming. So you're going to have to testify most likely at some point in time. It's going to be under oath. And then generally speaking, when you have your hearing, if the parties can't work out whatever the outstanding issue is, the judge is going to make a decision or he's going to take some action in furtherance of that decision. If it's a medical question, if it's a question as to your level of disability, the judge might order depositions from the doctors from the two sides, and he'll set a deposition schedule and set a return date and ask for summations, which is your argument in furtherance of your request. But he'll set that schedule and it'll map out how your case is going to go moving forward. So that's generally how a hearing would proceed from beginning to end. What are some of the best practices for injured workers at their workers' compensation hearings? What should you do when you're appearing for your hearing? When you appear for your hearings, act appropriately. Please don't eat. Please don't drink. Please don't be sitting in the bathroom. Please don't have the TV on in the background. Please be in a nice, quiet, indoor, well-lit room with no distractions. Having a dog barking in the next room is going to drive everybody crazy. Do the best you can to try to keep that to a minimum and makes your case smoother and easier and better for everybody if those distractions are eliminated. So please do the best you can to limit those distractions. You know in advance when you have a hearing coming up, trying to plan for it a little bit. If you can have somebody come over and watch the kids and the dog for an hour while you do your hearing, it's worth so much. When your hearing is being conducted and carrying on, don't talk over people when they're speaking. Let the person finish speaking, and if you have something to say, you can politely ask to say something. Generally speaking, I like to know what my clients are going to say if they're going to say something on their own. So make sure you clear it with your lawyer ahead of time. Avoid being in public places. We've had clients take hearings from a bus, from a subway. Please, prior to be home, it's so frustrating when somebody picks up the phone and they're in the supermarket and they say, I completely forgot I had a hearing today. What do you want to know? Well, the judge is going to say, if you completely forgot you had a hearing, it must not be that important to you. It's not going to work in your favor. Be smart about it. If you're logging in virtually, like I recommended that we all do, please dress appropriately. You don't need to wear a suit or a shirt and a tie, but please don't wear your A-holes live forever t-shirt. Dress as if you were actually going to court that day. Make sure your background is appropriate. Shut your TV off. Your Samantha Fox poster from 1988 on the wall behind you. Please point the camera in a different direction. Make sure you're in an appropriate setting and you don't have any stupid stuff going on behind you. The presentation shows the parties involved and shows the judge that you're serious about your case and that you're not just taking this as lightly, that you want to get the awards that you're entitled to. So dress like you're going to be serious. Okay, it's very, very important. Make sure you're comfortable for the hearing. It might go an hour. It might go longer. Make sure you're sitting in a place where you can comfortably conduct yourself the way you should conduct yourself in court. Please don't be laying in bed with the phone hanging over your head. Sit up, be respectful, be comfortable. Sit there as though you're sitting in a courtroom. That's the expectation, and we won't tolerate any less than that. And behave as though you're sitting in a courtroom. We all take this very seriously, and if you don't, the judge is not going to take you seriously, and it's just going to hurt your case. Other small things, try to log in early, whether it's virtual or you're going to call in. Make sure your lawyer knows you're ready to roll. Try to be a few minutes early in case the case does get called early. If you have a 1:30 hearing and the judge had a 30-minute 1 o'clock, and that 30-minute 1 o'clock went only for 10 minutes, the judge is not going to sit around and they're going to try to move their calendar along and they're going to try to pick up the next case. So that 1:30 might be called at 1:10. Be ready, be on the ball. Your case might be called early. By the same token, your case could be called late. We've had a 1 o'clock case get called at 3 o'clock. It happens. It happens a lot. Don't miss your hearing. That's probably the biggest tip I can give. Missing your hearing shows that you're not serious. Missing your hearing shows that you don't care. Missing a hearing almost always results in your case being closed. Your case gets marked NFA, no further action until you reopen the case. So it's going to delay your case. It's going to delay your benefits. It's going to show the judge that you're not serious. It's going to be there every time the judge opens up your file. Don't miss a hearing. How should injured workers prepare for their workers' compensation hearings, and what are some of the things they should do in advance? Prepare with your lawyer well in advance. Don't call your lawyer the morning of or the night before. Call them a week ahead of time. Call them 2 weeks ahead of time. You get your hearing notice in the mail the same time I do. If you're not sure what your hearing is going to be about and what's going to occur at your hearing, call your lawyer. When we go to a hearing, the judge is going to say, we need to do X, Y, and Z, and we're coming back on this date to talk about this. So you should know for the most part what's to come at your next hearing. But if you don't, call your lawyer in advance so you can be clear about what's going to happen at the hearing so that you can get together any evidence that you might need to help with that hearing and what's going to be discussed at that hearing so your lawyer can get the medical evidence he needs if that's what's needed. It gives you both time to prepare and to go forward effectively when the judge calls your case. You don't know how many times people call up and I hear every four-letter word under the sun and I say, look, I'd rather you blow off your steam now. If you want to yell and scream and curse and get it off your chest now, please do it now instead of doing it in front of the judge. If you fly off the handle, if you start blowing off steam, if you start venting in front of the judge because you're frustrated, you have just hit the big red self-destruct button on your case and it's over. Don't do it. Or if you're going to testify, prepare your testimony, what the particular topics you're going to be discussing. The one thing that's going to happen if you are going to testify, you need to be upfront. You need to be honest about everything. You need to answer questions clearly and concisely. What does that mean? Answer the question that's being asked and no more. And if that question can be answered with a yes or a no, just answer it yes or no. And by the same token, if you don't know, please, for the love of God, don't guess at a question. You could say, I don't know. Please rephrase the question. I don't get it. There's nothing wrong with that. Don't guess. So yeses and nos are fine. Keep your answers short. Keep them on point. Don't start running away. People try to give the whole story of what happened to them in the answer to one question. We know what we're doing. We're going to ask you a lot of questions. Answer the question. Let us move to the next one and get the answers we need the way we need them. Don't take it over. What should injured workers avoid saying or doing at their workers' compensation hearing, and what mistakes can ruin your case? First of all, and this is a big one, don't be too accusatory. My boss is the biggest a-hole on the planet, and my boss knew that the forklift was broken. Okay, maybe that's true, but it doesn't really matter. Workers' compensation, at least here in New York State, is a no-fault system. We don't need to prove that somebody else caused your injury and caused your accident, and we don't need to disprove that it was your fault. It could be entirely your fault. It's a no-fault system. It's here to protect anybody who's injured while working. Be honest about your injuries and their impact on your life, but don't overplay it and also don't downplay it. Some people will sit here and tell a judge how their broken pinky has impacted their day-to-day life and they can't do anything anymore, and they sit in their lazy boy watching reruns all day crying because their life is over because of a broken pinky. And by the same token, we see a lot of these big tough construction workers almost get their arms ripped off and they're like, yeah, no big deal, I'll go back to work, I have 2 arms. Don't overplay it and don't underplay it. Be honest with your doctors about the impact on your life and the insurance company's doctors, and be honest during your hearing. Keep your stories consistent. So your conduct in court might be the most important factor in changing the outcome of your hearing. How you present yourself. We've had great cases that I have to salvage from the gutter because the client is sitting there listening to their boss testify, and maybe their boss is being a little misleading and a little inaccurate. Next thing you know, my client's yelling and screaming. Stop. You're only making it worse. When people are less than honest, it shows most of the time. And everyone is a judge of character to whatever degree, and that goes for the judge. Don't sit there and yell and scream because now you're shifting the tide in the wrong direction. Let your lawyer take care of it. Always show respect during your hearing, despite what you might feel about your employer or the insurance company or the judge, whoever you might not like. You're in court and you're there to show respect to everybody. No foul language. Don't raise your voice. Don't speak over people. You also have to understand, and this is important and goes hand in hand with speaking to your lawyer well ahead of time. Each hearing has a specific purpose. Your hearing is not just an open forum to talk about anything and everything that has to do with your case or has to do with your life. You might be in court to discuss average weekly wage and to set your wage, which corresponds with your benefits. Don't start yelling and screaming about the insurance company not accepting your settlement demand. It's irrelevant. The judge is not even going to talk about it, and all you're doing is aggravating the judge. And and that might work against you. So focus on the topic at hand, focus on getting what it is that you want from that particular issue and moving on. And folks, with that, I thank you. If you guys have any other questions and you want to call me, please feel free. 212-406-8989. My name is Rex Sikowski. For any legal question that you want some help with, please feel free to give me a call. I'm always happy to help. I do what I can for everybody I can. Thank you so much, and I look forward to speaking with you all soon. Have a wonderful rest of your week.